I'm going to check and see if they're ready.
Okay.
Back on the record on State versus Rosario. Mr. Rosario, his attorneys are present. State Attorney's Office is present. Ready? All right, experiment. Yeah.
Jurors enter.
State recognized presence of the jury.
We do, Your Honor.
Defense?
Yes.
Welcome back, folks. Ms. Barrow, you may proceed.
Thank you, Your Honor. To the jury, I get to address a few things that the defense counsel said to you. And there are a couple things that I want to point out. One of the things he mentioned to you was he started off by talking about the fire department. And he started talking about the broken windows and that the windows were closed and therefore, I think the inference was that nobody entered in through a window. And I want to talk to you a little bit about that because if you think about that, think about it in terms of the fire department arriving on a scene where there is smoke in a house. There's clearly fire. And as you heard them testify, they have tools to break windows. So members of the fire department do not walk up to a window. They do not take their hand and try to slide the window up or over. What they do is they walk up to a window and they smash it to ventilate the house. So the testimony you heard from the fire department was that windows were closed. It said nothing about the fact of whether or not they were locked. And an unlocked window allows a person to enter. The defense also mentioned that there was no evidence of a struggle. Defense counsel told all of you that you didn't hear from an expert witness that would talk about a struggle between 83-year-old Elena Ortega, a woman who had recently had surgery, a woman who had hip replacement, a woman who couldn't walk without assistance, versus Juan Rosario. members of the jury, you can use your common sense in terms of how well that struggle would have went. There's no evidence that she struggled. There's evidence that she put up her hands and she said, "You don't have to do this." And there's evidence that after she put up her hands and said, "You don't have to do this," that man found her skull. There does not need to be any evidence of a struggle because none exists. Defense counsel also said Janet came forward because she was under the threat of prosecution. Really? Because Detective Ford, who's sitting in this courtroom, he told you on the witness stand he had no leads. This case was not solved. What prosecution? What evidence? The members of the Orange County Sheriff's Office had nothing. So under the threat of prosecution, there's absolutely no evidence of that. In fact, there's evidence to the contrary. They had nothing until Janet Gutierrez came forward. Defense counsel mentioned that the defendant must have ridden his bike simply because the bike was swabbed, I guess. But I can tell you, members of the jury, it is not the state's theory that he rode his bike. During the course of evidence in this case, you saw a map. And on that map has the locations of where the victim's house was and where the defendant's house was. And if you go by the street, and this is not cutting through anybody's yard or anything, 14 houses. If you take the roadways between his house and her house, 14 houses is what he would pass. It's the state's theory that he very well could have walked that distance. And the defense brought up the bicycle because, 3 suitcases. Clearly, he wasn't able to carry 3 suitcases. Well, Mr. Rosario, on foot, can absolutely carry 3 suitcases. And I say that if anybody has ever been to an airport and have seen people with children, and how many bags and items they are able to carry onto an airplane, just taking that fact alone, is this grown man, is he able to carry 3 suitcases? Absolutely. 14 houses away. Not difficult to do. Defense counsel mentioned that there was a mop in the closet. And Janet Gutierrez switched up where the mop was located. And so therefore, it's the wrong mop. That is not factual. Janet Gutierrez described the mop to you. And it's the mop head with the strings on it. That's the mop that she said she used to mop up the blood. And that's the mop that they tested for the presence of blood. And that's the mop that had blood on it. Now, mops, by their very nature, can move. You use it in a moving fashion. And so for the mop to, at one point, be located in the closet on the inside, and then to be found 9 months later in the carport, does not mean that it's a different mop. It simply means that that mop moved from one place to another within 9 months. It is the mop that she used to mop up blood. Defense counsel mentioned that there was a pendant found in a female's drawer. It's the pendant that says Caesar on it, that belonged to Elena Wilson. And it was in a drawer in his bedroom. And defense counsel said, well, clearly that was a female drawer. But here's the problem with that. Janet Gutierrez moved out of that house. She testified that within a month of the murder, she had moved out. So that pendant sat in his bedroom, in his drawer, for about 7 or 8 months. And it's the pendant belonging to Elena Ortega. If this was Janet Gutierrez's jewelry because she liked jewelry and she was a part of all of this, she would have taken it with her when she left the residence. But she didn't, because it wasn't hers. It was his, in his bedroom, and it's in his drawer. Now, defense counsel then started talking about Janet Gutierrez and called her a drug addict. And I want to talk to you about her addiction to drugs. Janet told you all that she had an accident to her back and that she got addicted to pain pills. And she told you that the other drug was Adderall, which she had a prescription for at one point for her ADHD. That is the extent of her drug addiction. That is the extent of her being a drug addict. With the exception of that she also mentioned that she likes to smoke marijuana and that she had smoking marijuana. Now, members of the jury, ask yourself, does this make somebody who is not credible simply because of those facts? Because if you take the fact that it's based on her back in addition to pain pills, or if you take the fact that it's marijuana, I mean, there are 3 states in the United States of America, Colorado, Washington, and Oregon, where you can purchase marijuana legally. And I submit to you that there are very credible people living in those states. The fact that she smokes marijuana and the fact that she had an accident and as a result of being prescribed pills formed an addiction which she is getting help for does not make her less credible. It just makes her who she is. So I want to talk to you about her credibility. Because, as the defense said, her credibility is a huge part of this case, and I agree. And if you remember, back to jury selection, Mr. Williams asked all of you about the testimony of one witness. What Mr. Williams said, and the question that he asked, is if you heard from one witness and you believe their testimony, and their testimony proves the crime to you beyond and to the exclusion of every reasonable doubt, could you convict? And all of you told all of us that you could. So here you go. Here's the very credible testimony of Janet Gutierrez. Because you have it. Here's what I mean. Janet Gutierrez told all of you that she was woken up at around 5:15 a.m. to the defendant standing over her, and he had blood on his face. And she described it as splattered blood. So test that. Because you as jurors, you should test the credibility of every single witness that sits in this chair. And the state of Florida wants you to. Please, test her credibility. So test all of the facts that she stated to you. And we're going to go in order. So the first one is that he's standing over her bed, and he's got blood splatter on his face and on his clothing. We'll test it. How do we know that that would be accurate? We would know that's accurate from the other evidence in the case, other testimony, and other physical evidence. And it's the crime scene photos. Because, members of the jury, this isn't a murder case where somebody was standing about 30 feet away and had a gun and pulled the trigger. No. This is personal. This is intimate. This is that man standing before her. This is that man taking his fist and punching her. This is that man taking an object and beating her skull. So based on that behavior, is it reasonable that there would be blood splatter on his clothes and his face? Absolutely. It makes sense. It's consistent with what you know. Next, she said, he showed her these suitcases. And there were suitcases that she knew didn't belong to him because she didn't recognize them. And she described those suitcases to you, and she said that they were floral and print. Well, test it. How do we know that that is actually what happened? Because you heard from Elena Wilson. She indicated to you that her mother, the victim in this case, had suitcases in the home, and they were of floral print. Completely consistent with the other evidence in the case. She then said that because of the blood, she had to mop up from the doorway to the door to the bedroom in the hallway, which makes sense because that would be the path of travel that he took into the house. And she told you all that she didn't recall exactly how much blood was on the floor, but she remembered that there was blood there and she mopped it up. Okay? Tested with the other evidence in the case. You have a mop. That 2 witnesses. The CSI church, she did a presumptive test, positive for blood. And then she sent it to the lab. And Tim Petrie, the FDLE analyst, the DNA guy, he confirmed human blood on that mop 9 months later, just like she said. She then told you that because of the blood, she asked him to take off his clothes and get in the shower. She then bagged his clothes and his shoes, put it in a trash bag. She told you that her boss was picking her up in about 45 minutes, and so she decided that she was going to take those clothes in that trash bag and take it to the 7-Eleven and throw it in the dumpster so that it would never be found. Well, test that statement. What do you know about that? You know that that is true because you heard from her boss. He told you that in September of 2013, Janet Gutierrez was working for him and that he picked her up for work and she had a trash bag with her. That's unusual. He remembers it. He told you that when he drove to the 7-Eleven, he watched her get out and go to the dumpster with the trash bag. Everything she says is consistent with the other evidence. She told you that she worked, and as she took the bus and got to the house, Juan Rosario told her to get rid of the evidence. Now, this is a woman who doesn't have a car. This is the day of the murder, so there are cops everywhere. So how does she get rid of the evidence? She buries it in the backyard. So she digs 3 holes, puts 3 bags, and buries it. Well, how do we know that this is true? We know it's true because 9 months later, members of the Orange County Sheriff's Office go out to the backyard of his house and they dig up a bag exactly where she had left it. She told you all that part of what he had stolen from Elena Ortega is cash. He came in with cash. Well, test that fact. How do we know that that's true? You heard from Elena Wilson. She talked to you about the cash her mother kept in the house. She told you specifically 2 photos of her and her brother. They sit on the dresser. They both have cash behind them. You heard from crime scene analysts. 1 envelope was found. So, is it consistent with all the evidence that Juan Rosario shows up at his house with cash? Absolutely. Completely consistent. She said that he stole jewelry from Elena Ortega. How do we know that's true? Test it. The reason why we know that's true is because 9 months after the murder, when they execute a search warrant on his house, in his bedroom, in his dresser drawer, there is jewelry belonging to Elena Ortega. Everything she says is consistent. She further tells you that Juan Rosario never returned home after that murder, that he was being taken around by his sister and his friends, and that they were putting him up in hotel rooms. Test that. How do we know that that's true? You know that's true because you heard from Detective Ford. Detective Ford was able to track down the business records of a hotel that has his sister signing for a room 6 days after the murder. Everything she says is consistent. She then says that she didn't come forward because she was scared. She said that she didn't tell anyone because she was fearful, because the defendant told her, if you say anything, I'll kill you, and I'll harm your sister. Now, how do we know that he said that? We know he said that because what is it that Janet Gutierrez asks for when she finally comes forward? She asks for immunity, and she asks for her sister to be safe. And we know that's true because Detective Ford confirmed that that was true. Members of the jury, every single thing that she says, every fact in this case is supported by testimonial or physical evidence. You have it. So the question of one witness, if they prove the elements beyond reasonable doubt, could you convict? The answer is absolutely 100% yes. You have everything you need in this case. And the reason why you have everything you need is because the defendant made 3 major mistakes. 3 of them. The first 2 are pretty obvious. The third one, he didn't see coming. Mistake number 1. He didn't wear a mask. That's a huge mistake. And one that he recognized. Because as you heard from the evidence in this case, when he broke into somebody's home, and it was probably between the hours of 4:30 and 5 a.m., when most people are home, that Elena Ortega saw his face. That's a problem. That is something he needs to fix. He needs to cover that up. And so he did. How did he do it? He beat her. Cover that right up. The second mistake that he made, which again is pretty obvious and that he recognized, he wore gloves. Huge problem. Because from his own statement, not wearing gloves, he left his fingerprints everywhere. He touched everything. You can look at those photos. You can see dresser drawers thrown about. You see all the stuff that he touched. Yeah, big problem. So, when he's back at his house, he thinks, all right, how do I cover this up? And he thinks, you know what? What if she's not dead? She's seen my face, and what if she's not dead? What if I wasn't successful the first time? So he comes up with a plan. And his plan to cover all this up, I'm going to light the house on fire. So what does he do? He takes the lighter that Janet Gutierrez says he never is without, because he smokes every day, probably got it in his pocket, and he goes back to Elena's house, and he lights it in 3 different spots. Fire. Evidence destroyed. I mean, it's brilliant. It was a really good decision. He took care of both issues. He took care of the eyewitness to the crime, dead. He took care of the fingerprints, DNA evidence, gone. Genius. But members of the jury, we are here because of his third mistake. The one he didn't see coming. The third mistake that he made, and the most important, is that he underestimated the courage of Janet Gutierrez. Because despite telling her, if you say anything, I'll kill you, and I'll harm your sister, she walked through those doors, she came in here, she sat in this seat, and as she sat in this seat, she pointed him out, and she told all of you everything that he did to Elena Ortega. Mistake number 3 could not be silenced, and he could not cover up. Members of the jury, you have everything you need to hold him responsible for everything he did to Elena Ortega. The state of Florida asks that you find him guilty as charged.
Thank you, Ms. Burr. All right, ladies and gentlemen, there's one additional instruction you don't have, and that's this. Both the defense and the state in a trial have an equal opportunity to call and subpoena witnesses. Now, beginning on page 17, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. I have the verdict forms up here with me. They're going to be sent back into the jury room with you. There's 2 pages. There's a verdict for count 1, and there's a verdict for count 2. Count 1 is the first-degree murder charge. You have 4 choices. Guilty of murder in the first degree is charged in the indictment. Guilty of murder in the second degree, a lesser included. Guilty of manslaughter, a lesser included, and not guilty. You'll notice there's a line beside each one of the verdicts. Pick one, and whoever the foreperson is, either put a check mark or an X, something next to the verdict so that we know which one you've chosen. Whoever the foreperson is, you must sign and date this form. If you don't, I have to send you back to the jury room to sign and date the form. The verdict as to count 2 is the arson count. Again, 4 choices. Guilty is charged in the information of arson of an occupied structure. Guilty of the lesser included offense of arson of the structure. Guilty of criminal mischief, the lesser included offense, or not guilty. And then again, sign and date the verdict form. Like I said, these will go back to the jury room once we're done. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The deputies will collect your devices and they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Any additional instructions requested by State?
No, Your Honor.
Defense?
No, Your Honor.
All right, thank you. We're going to do a little bit of moving around to folks. Jurors number 337, starting in the second row, 26, 502, 410, 509, and 445. So it should be you two and then the front row. Follow the deputies. They're going to take you to the jury room to collect your belongings and then bring you back into the jury room, and I'll have separate instructions for you in just a minute. The rest of you just hang with me for a second while we get that done. Man. Nothing bad is happening to them. The remaining jurors, the remaining 12 of you, may now retire to consider your verdict. Please take the notebooks and the jury instructions with you. We will send the exhibits and the jury verdict form back to you in just a moment. Thank you.
Jury's excellent.
Ladies and gentlemen, you're the alternates in this case. I'm sure you figured that out. Normally we discharge the alternates at this point, but in your case we cannot discharge you. You remain on this panel and you remain subject to the rules of being a juror, which include no talking to anyone about the case, no watching television, no reading anything about the case. All of the rules I've given you up to now remain in effect. If your fellow jurors return a verdict of first-degree murder, you will have to return for the penalty phase in case we need you, in case one of them cannot serve, and that is the reason you're not being discharged. There's several weeks between now and the penalty phase, and we have no idea. Something unfortunate might happen, and a juror may not be able to serve, in which case one of you, or more than one of you, if that's necessary, would have to serve as jurors, which is why you remain under the same rules that you've been governed, and you are not discharged from jury duty. If you all would be so kind as to, I'm going to hand the deputy this pad, give me your juror number and a phone number at which my assistant can reach you. We will call and let you know what the verdict is and whether or not you will be needed for the penalty phase. You are being given a sheet of paper that has a phone number to call after May 5th. If you are needed for a penalty phase, you can call that number and it will give you the date and time that the penalty phase is occurring. All right? Any other instructions requested by state of the alternates?
No, ma'am. Thank you.
Defense? All right. Have a good evening. At this point, you're excused. The deputy will escort you all out and give you the opportunity to give us a phone number to reach you. Yes, ma'am.
Please leave a notepad while we check.
Have a good evening. Thank you. That's fine. If they come back, we'll start over again with certificates. It's a little strange because of I don't know what we're doing here. In terms of penalty phase. Mr. Rosario, you are still under oath. You were placed under oath this morning. Are you satisfied with the job that your attorneys have done in this case for you so far?
Yes, ma'am.
Do you have any complaints about them or anything that they have done in this case?
No, ma'am.
Is there any witness that you wanted them to call that they did not call, or any deposition you wanted them to take, anything like that that they didn't do that you asked them to do?
No, ma'am.
All right. Thank you very much. Anything else we need to address, folks?
No, Your Honor.
All right, we're in recess awaiting verdict. I would like the attorneys to please come look at the evidence that's being sent back to the jury room and make sure that what's going back is what's in evidence and what you all want going back. We need to send a box of gloves back to the jurors. You know what? I didn't instruct them. Do you have any objections to the deputies telling them that if they're going to put their hands in the evidence bags, they need to put gloves on?
They didn't object.
All right.